Yeah, ladies and gentlemen, welcome to this first round and first panel of this interesting workshop we're here for in Prague. And today this first panel is going to focus in essence on the balancing of human rights and the very much notion of delegations and non-state actors in armed conflict. We have the pleasure to have with us in the program here, we're going to be to make a small change in the order of the presenters. So first, we're going to have the pleasure to hear from Mohammed Imran Khan and from Mariam Kassim, who is joining us online. Some words for our speakers. Mohammed is, in essence, a postdoctoral researcher with the Instituto Jurídico Portucalense, which is in Portugal. And along these lines, his research focuses on non-state actors, but also the interaction between trade policies when it comes also to the European Union. And in essence, in the quest to find out whether the different trade policies actually diversify human rights, or we can kind of strive towards a more universal application of human rights. And of course, Mariam Kassim is also an assistant professor at the Shahid Benazir Bhutto University, Seringal in Pakistan. Mohammed and Mariam, also that you are with us also virtually, the virtues of technology. This workshop is about learned technology, so we practically see the manifestations of this. The podium is yours. You have about 20 minutes to present to us your ideas.
First of all, thank you so very much for having us within this at this venue. And within our presentation, the first part will be presented by Mariam Kassim, and she's joining us online, I hope. Because I cannot see her.
This was what I said, so I hope that I also stand firm to my word.
Exactly. So we would like to request Mariam Kassim, if she's ready, to begin with presentation.
Otherwise, Mohammed, maybe you should take the lead.
Yeah, exactly. Let's see.
But of course, now the organizers will give us a specific bureaucratic details.
Yes.
No, she's not.
Am I?
Sure. No, she's
okay.
Not.
Then I believe I'll go on with the presentation.
Okay.
Yeah, so today our presentation is about the role and relevance of non-state actor in international legal order and the positive contribution that the non-state actors play in the environmental protection. We do know that over the time, the non-state actors have gained enormous amount of institutional, political, and economic potential. However, there is a dichotomy of between the role and relevance of non-state actors and its potential within the international legal order. The reason for this is the reluctance of the state to give recognition to the non-state actors, because this will lead the recognition and the sharing of the unique status of the states that they hold presently within the international legal and political order. This attitude actually undermines the uniform application of the international legal order, and it amplifies, on one hand, the negatives of the non-state actors to the environmental protection with impunity to hold them accountable, and it overlooks the positive contribution of the non-state actors to the international to the environmental protection. I would like to sorry, because I missed. The non-state actors have both positive and negative contribution to the environmental protection. Worldwide, there are 160 million people that are living in the territories that are either directly or indirectly controlled by the non-state actors. And non-state actors protect the environment both directly and indirectly. Indirectly, it is called conservation at gunpoint. For the non-state actors usually make the, for example, the forest or the green areas inaccessible for the for the national armies or private enterprise or the settlers and extraction companies, they do so in order to provide safe hideouts and recruitment facilities for their own purpose. And for this purpose, they keep the forest or the greenery unexploited to gain their own interest. An example of this trend is the non-state actor that actually operates in Mali, Sahel, or PPK. And then we have the direct protection of the environment by the non-state actor. They do protect the environment to get social legitimacy. They protect the environment as a political vision. They maintain forestry and environmental policies, and they work with the civil society organization for the environmental and wildlife protection. And they resist the oil and gas exploitation. And we also have examples of such attitude by the non-state actors, such as the Karen National Union, the People Protection Unit, and the Ogaden National Front that operates in different parts of the world. Now this...
Mariam is actually a journalist.
Okay.
And if she wants, she more than welcome to grab some. Take a chicken on you, so. Down, can you unmute yourself? Excuse me. I mean, it's a Zoom. Can you hear us?
The mic is muted.
Yeah. Well, it's all online technology.
Am I audible?
Yes.
Yeah.
Yeah. Good afternoon, everyone.
Hi.
Hi. To continue, point?
Yeah, I just would like to ask her if she's okay with going with the fourth and fifth slide, or if she want me to go with those slides.
Muhammad, you start, and I'll continue with the second, and then you conclude.
Because I already presented the two slides because you were not online. So do you want me to continue with the fourth and fifth slides rather?
Yes, you continue. I had connectivity issue. For that reason, I was unable to connect. So,
yeah. Okay, then I'll go with the fourth and fifth slide quickly. Okay, so we highlighted that there is a dichotomy between the roads.
Just a second, it didn't change on the screen.
You want to move to the fourth slide?
It did, but not.
Okay.
The point.
Okay.
Yeah.
So there is this dichotomy between the role and relevance of non-state actors, and it undermines the uniform application of the international legal order, and it further amplifies the environmental negative role in terms of environmental deterioration, and it overlooks the positive contribution that non-state actors actually play in the environmental protection. So there could be certain legal and political tools which we can use in order to provide a legal and political backing to the positive and establish accountability for the negatives of the non-state actors in terms of the environmental protection or deterioration. And this will provide us a kind of platform where we can balance accountability and legitimacy. And this integration of the non-state actors could be done through multiple ways. First of all, the reconstruction of the international legal and political order. We need to bring up fundamental changes to the international legal and political order, where we can have equal accommodation of both the state and non-state actors, and also to bring the non-state actor within the ambit of international rule of law, where all the influential actors of the international at the international theater should act in accordance with international legal rules, and they can be held accountable in case of violation. Since we said that the states are always reluctant to share their unique status with the non-state actors, so it will be hard to for the state to enter into binding agreements with the non-state actors, so we can come up with non-binding declaration at the face of the state reluctance. And we have one example of this attitude of the Polisario Front, where it is Polisario Front is a liberation movement which is fighting against Morocco, and in 2015 they submitted a unilateral declaration to the Geneva Convention that they will abide by the the Hague regulations in the Geneva Convention in its armed engagement with Morocco. Also, another suggestion could be IHL, which is presently more into the humanitarian aspect of the armed conflict. It emphasizes more on the human protection, and environmental concern ranks very low. Environmental protection concerns very low within the IHL within the IHL rule. It is more of anthropocentric. So the focus should also be equally balanced on the environmental protection of the IHL, rather than only focusing on the human protection. And I will just conclude our presentation with saying that it is imperative that we increasingly place human needs in wider context of the ecological ethics. Thank you so very much, you all, for listening.
Thank you, Mohammed, and Mariam also, that eventually contributed to this presentation, even though it was presented orally here by Mohammed. And we are going to go also to the second presentation now, and then all the questions are going to be amassed and asked in the end. So for the second presentation, we are very glad to be hosting Barnaba de Dieudonné. Barnaba, who is actually a PhD candidate in the University of Montreal in Canada. And in essence, he has a very extensive career. He was previously in the field of social communications, but he's making this switch now to the legal world. And finishing now, you're going, Barnaba, to present, to defend your thesis in a few days. And eventually your fields of interest span around international human rights law, international migration law, and in essence, also the junction between business and human rights. Barnaba, we are very glad to have you here, and we are looking forward to your presentation.
Thank you, Professor. It's a great pleasure for me to be with you this afternoon. As you know, we thank the Minerva Center for that invitation. As you know, the title of our presentation is The Use of Derogations as a Remedy to the Thorny Problem of Contradictions of Human Rights Obligations in Armed Conflict. The fact is that human rights target the obligation of states first to individuals. States, parties undertake to respect, to ensure to the benefit of individuals the right that some instruments guarantee. We can consider, for example, the ICCPR and the other Convention of the Regional System of Human Rights, for example, Inter-American System, European System, etc. The Inter-American Court of Human Rights states that, I quote, the first obligation assumed by states parties under the Article 1.1 of the Convention is to respect the rights and freedom recognized therein. That's the case of Mosquito Divers and the case of Velasquez Rodriguez. that obligation is relevant in peacetime as well as in peacetime and in wartime also. According to the Human Rights Committee, the General Comment number 31, both spheres are complementary. That means not mutually exclusive. There are the possibility in wartime, by the virtue of the use of force, to decide against some human rights provision, just to indicate, to assure the self-defense of the state. And there is the permission to kill to protect the rights of individuals. That's in the member of the populations. And there are circumstances in which it may not be unlawful to shoot to stop individuals when the threat to life is grave but not imminent, according to the Geneva Academy of International Humanitarian Law and Human Rights. And the Human Rights Council talked about the protect life principles. That's when a life may be taken intentionally just to protect the life of other person. People, they say that it's a guiding star to the protection of the right to life. So the primary aim of that principle is to save life. The idea that we want to support is the fact that the state can take several measures that are contrary to human rights in order to protect human rights. That's a sort of a sort of contradiction in international human rights, and you will find that contradiction in wartime also. And that contradiction highlights the contrast between the obligation of states to guarantee the rights of the individuals in wartime, and the on the fact that they make human rights violation just to protect the rights of the individuals. Based on that, in those contradictions, we ask the following question: how can states solve the thorny problem of contradiction in human rights, obligation in armed conflict? We propose the principle of the obligation that as a possible solution to solve that problem, the problem of contradiction of human rights in wartime. In order to structure our thought, we are going to see 2 points. The first one is just to analyze a little bit the problem of contradiction of human rights obligation in armed conflict. The second one is to talk about more the obligation as a remedy. The problem of contradiction of human rights obligation in armed conflict, that in order to talk about that, we must talk about the human rights to see the principle of interdependence of human rights and the possible contradiction between human rights provision. The principle is that human rights provisions are interdependent. The interdependence is omnipresent in international human rights. That means, according to the Vienna Declaration of Program of Action, the paragraph 5, I quote, all human rights are universal, indivisible, interdependent, and interrelated. We have a lot of some position that divide human rights between civil and political rights and other economic and social cultural rights. When you consider the rights, the content of the provision that we can put on those categories, we find that they are interaction, they are all interdependent. That means that when one of the consequences of the idea of interdependence of human rights, the effectiveness of one provision can imply the realization of the other. On the contrary, On the other hand, the violation of one can be the violation of others. We observe the contradiction between human rights provision. For example, if you consider the right to strike, the contradiction that we talk about is the fact that when we use a right, it can be the violation of the rights of other people or other group of people. For example, if we consider the right to strike, that the ICESCR Article 8D guarantees, if a worker in the public transportation decide to use that work, and the other members of the population can feel that their right to circulation is violated, it's a violation of the right to circulation, because no metro, no subway, no bus, no tram, etc. They cannot go from one part to the other one. We find a lot of cases like that during COVID-19 pandemic. There was contradiction between the right to circulation and the right to health, and even the right to life, because I can go where I want, but when I go, I can transfer the virus to other people. And the people who receive it, they can feel that it's a violation of the right to life or the right to health. The idea of contradiction exists. We find it in the context of armed conflict. The fact is that states have obligation to guarantee the protection of the right to security, the right to life. Professor De Schutter identifies two aspects of that protection. The first one, it's the obligation of states to avoid being responsible for arbitrary arrestations. And the protection against torture. The second one is the obligation of states to guarantee the security of individuals. But the entity that can be responsible for the violation of those rights can be third parties. That's mean in the context of armed conflict, it can be the enemy. For that reason, states must take some necessary measure to protect their populations, and those measures can be on the fact a sort of contradiction to other provision of human rights. For example, if we consider the right to life, the right to security, and the right to privacy, that means states or the adjunct can be faced with a situation where they are obliged to violate the right to privacy in order to protect the right to life. That's the idea of contradiction of human rights that we talk about. And when we want to study that problem, the question is how can state what can state do to avoid that problem of contradiction of human rights violation in wartime? And what we propose is the use of derogation. That's the second point that we are going to see, derogation as a remedy. Derogation, according to Enbel and Tiguja, two scholars, they have a book that interprets the Inter-American Convention. They say that the rationale of derogation, the aim of derogation is to maintain the balance between human rights, between rights and freedoms of individual and the safety of the community. That allows state to derogate from certain rights if it's necessary to face the exceptional circumstances that are threatening the life of the nation, etc. The Inter-American Convention consider a rule of interpretation of that provision. That's when I talk about that provision in this Inter-American system, it's Article 20 27.2 of the convention. It's good faith, according to the Inter-American Court of Human Rights, Inter-American Court, state must interpret that provision in good faith. They must use that principle, the principle of good faith, to interpret that convention. I quote, and Article 27.2 must therefore be interpreted in good faith and keeping in mind the object and purpose of the American Convention. That's the advisory opinion OC 87. That's the name of the advisory opinion. The Human Rights Committee say that state must interpret the covenant in good faith in accordance with the ordinary meaning to be given to its term in the context. We'd like to underline three elements when we are talking about the obligation as a remedy. The first one is the fact that there are provisions in international law, precisely human rights, that give the states the possibility to use the obligation. They talk about the existence of war, public danger, or another emergency. It must be a threat to the independence of the security of the states that use the obligation, according to the Article 27 of the Convention of the American Convention on Human Rights. It's almost the same for the European Convention also. But in the American Court of Human Rights, use the fact as a criteria to appreciate the application of that rule. I quote, according to the fact, the state must be tailored, that measure must be tailored to the exigencies of the situation. It is clear that what might be permissible for one type of emergency would not be lawful for another one. It's a question of fact. And the suspension does not target the guarantee or the right, but the limitation for a full and effective exercise. Once more, the advisory opinion 887. The European Convention, Article 15.2, consider this almost the same thing. The restriction permitted under the convention to be said, right and freedom shall not be applied for any purpose other than those for which they have been prescribed. The African Convention does not have a provision like that. They consider is the fact that they do not consider as a non-admission of or permission of the obligation, according to some scholars. If we remember the context of COVID-19, according to Suparma Kodri and other scholars, in the research, they find 33 cases of the obligation of the ICCPR. They say that in an average, the obligation lasted 41 days. But another condition, it's proportionality. That implies that the derogatory measures shall be strictly necessary for a certain period of time and for a specific goal. Or the criteria, a necessity that implies the restriction must be prescribed by the law, by law, and besides necessary to protect the public safety. So those kind of measures must be temporary and they must be lifted immediately after the period, after the emergency. The derogation must be consistent with other international human rights and humanitarian law, and that decision cannot be in contradiction with the obligation of states in international law. And the state can use reservation also to as a possibility to, when they think that they cannot respect some, as a sort of derogation, although reservation is not a reservation and derogation are not the same, but they can use the reservation also according once they respect the Article 19 of the Vienna Convention. The general comment of 24 give a list of provisions that can be subject to reservation. And the derogation, the second element that I want to underline is the fact that the derogation have a limit. There are a body of rights that state cannot derogate. Some rules of law, that means I thought the non-derogable status of certain right is also associated with the claim to be jus cogens or peremptory, according to William Shaba. In the Article 27.2 of the Inter-American Convention gives a list of rights that state cannot derogate. We find that in all the other instruments that allow that codify the principle of derogation. And the derogation cannot be, I quote the Inter-American Court, cannot be involved in discrimination on grounds of race, color, sex, language, religion, social origin, etc. And the derogation must respect some procedural safeguards. For example, habeas corpus, amparo. There are, among others, some judicial remedies that are essential for the protection of various human rights. And the prohibition of arbitrary detention or imprisonment cannot be suspended during armed conflict. That it's the same for peremptory norms, according to the General Comment 29. Lastly, the procedure. The derogation must respect a sort of procedure. The conventions, the instrument that allowed states to use derogation establish a sort of procedure. For example, they must inform the other state parties for the Inter-American Convention system. They must inform the Organization of American States, and they must say the reason, the date, and the date of the suspension, of the termination of the suspension. And they must inform also the other organ of the Organization of American States.
But about another 3 minutes.
Yeah, no problem. I think we almost finished. The court has, in the case of Espinosa Gonzalez Silvers Peru, the court says that there is no evidence that the state respect that obligation. And the court says that the non-compliance of that obligation is a breach of the obligation that we find in the Article 27. We find the same thing in the European Convention. The state must inform the Secretary General of the United Nations for the ICCPR, and for the European Convention is the Council of the Ministers. So it was a pleasure for me to talk to you about the aggression of human rights in wartime. And we see that there are a lot of formality that state must respect. And if the state respect all those formality, if the right, if the instrument say that the state can deal with that right, and if the state respect the procedure, in our opinion, there is no, we will not talk about the responsibility of that state for the violation of human rights. On the contrary, we can talk about the responsibility of the state That's mean if the state does not respect the conditions and the victim can ask for reparation. That's all we'd like to share with you. Thank you for listening to us.
Thanks to the participants, Mohammed, Mariam, and Barnaba. Of course, we're opening now the table to any questions. If I can make use of my prerogative, let's say, as a chairman of this session, and to start to warm up the climate with two questions, one for Mohammed and Mariam, and one for Barnabas. I will start maybe from the last one, Barnabas. You gave us a very eloquent description about the regime of reservations, and you spoke about a contradiction of the application of human rights when it comes to the cases of emergency. I leave aside the issue of contradiction or not. I want to focus now on the derogations. Do you think, though, that using derogations, in essence, because you advocated for the use of derogations, aren't you afraid that thus we create states, and generally state actors, and non-state actors, protagonists of international law, which want to disengage rather than engage with international law? And if that's the case, is this something positive for international law? This is the question. So the overuse of derogations. And the question for Mohammed and Mariam, you spoke about the positive impact that non-state actors may have. And I personally am very happy to hear about this. And I think you have a point, because sometimes we associate non-state actors only with the laws of war, but they have a kind of broader usage in international law. My question would be, though, and you spoke specifically about environmental law, do you see any positive aspects of non-state actors when it comes to the laws of war and wartime, which is a more dismal landscape? And in concreto, to make maybe things more kind of tangible, what's your comment about the institution by ISIS? Some years ago, ISIS instituted tribunals and waged trials. Do you think it's a positive or negative result and development, the institution of courts by ISIS, a non-state actor, during an armed conflict? So these were my questions. Maybe Barnabas can start, and then Mohammed and Mariam, you can give your answer, and the rest of participants, of course, prepare their own questions so to inform the audience.
Thank you very much, Professor, for that question. So I understand your point, but what I understand, it's a rule of law, it's a provision that we find in some instruments. So if the state use that provision, if the state respects the procedure, I don't see the problem, even though a lot of states use it, but we can find the problem at another level. That means I know that it's a bit difficult if we can have another instrument that prevent them from doing it. But now there's this, if we take the ICCPR, the Inter-American Convention, the European Convention, it's written that the state can use it. Me, I don't. Even though they are using it a lot, I cannot. I don't have an argument to say that they cannot do it. If there is a problem, as you say, we're supposed to find a solution. But for the moment, I cannot find an argument to say that they cannot do it.
Yeah, they can do it. I think it's advisable to do it.
Yes. If they respect the procedure, the notification.
We should put some limits, maybe to think about some limitations, though, to the right of the states to use reservations.
But there are a lot of limitations in the convention, because there are a lot of rights that they cannot use. For example, habeas corpus, and there are some instrument that does not have that. An article that gives the state the possibility to derogate. For example, the Convention Against Torture. That's mean for me, what I see in the conventions, I don't really have an argument to say that they cannot do it. But the problem, if they do it, if they say that they are going to do it and they don't respect the procedure, they are responsible for human rights violation, and the victims can ask for reparation.
Thanks, Barnaba. And maybe Mohammed now, and also Mariam, you're far away physically, but of course technology engages us with you. So we look forward to your participation and answer to the question once again. What's happening with other sectors other than the environmental law?
Yeah, I believe there is a saying that justice rushed, justice crushed. So in cases of ISIS, I believe they are always or ISIS or other similar non-state actors, they are always in rush to punish those accused. And I believe this is not in line with the right to fair trial standard of international human rights law. We have similar kind of legislation that was enacted for 2 years, Protection of Pakistan Act. And this act actually provided for the military courts to try civilians accused of terrorism. And there was a lot of mismanagement or injustice done to the civilian. So in my opinion, I'm not very learned about the ISIS role in the prosecution that were taking place, in my opinion. Whenever there is not an institutional justice system, they are always in rush and justice is always crushed. So I believe there may not be a positive contribution from the non-state actors in terms of civilian, the judicial system.
And when it comes maybe other fields than environmental law, have you traced any other positive contribution of non-state actors to other fields of law?
I was just mainly focusing on the environmental aspect, in the environmental protection, because obviously there are serious damages that has been done by the non-state actors to the environment in itself. But these are the positive things, and we were mainly focusing on the positives rather than the negatives.
Mariam, do you want maybe to add something to these thoughts? You're a bit muted, Mariam, so...
You're muted.
Yes.
Now,
Yes, we focused on this positive, that their indirect positivity and contribution to the environmental protection, that as the forests, they are safe hideouts and places for the recruitments of these non-state actors, so they make it inaccessible to the national armies and public and private enterprises to move there. So they kind of try to reserve the forest, and they also resist against the oil and gas exploitation in the areas. And plus they are also engaged with the civil society for the protection of wildlife. So this was the main idea that we were focusing on.
Thanks, Mariam, indeed, for clarifying the scope also of your research. Yeah. And to open the table, of course, yes, Yael, everybody has many questions, of course, very logical and very enticing. So we can start with Yael and we can go forward. Yes.
Okay, so I have a question for Mohammed and Mariam. I think, correct me if I'm wrong, that when you speak of non-state actors, you're actually speaking of organized armed groups. And I'm not entirely sure that this is what you mean, because you mentioned certain non-state actors that are contributing positively or acting positively for the protection of the environment. And I don't know whether these are organized armed groups or just environmental protection groups, because the names are not familiar to me. So I'm just guessing. So this is just maybe just a clarification. And if they, well, okay. So let's start. Are they armed groups or the Karen?
Yeah,
they are armed groups.
They are mainly the armed groups, and our research was mainly focused on the positive contribution of the armed
groups. Okay, okay. And the other thing is, I find it interesting that you.
I add something. As these non-state actors, they are not recognized in the international legal and political orders. So their positives are not acknowledged, and neither their negatives are sanctioned. We suggest to bring these non-state actors in the international legal and political order, so their negatives could be punished and it could be backed by sanctions, and their positives shall be recognized.
Yeah,
so
Yeah, but okay, so about this, I'm not sure how organized armed groups would or would not be recognized in the international. I think the fact that we have a category of organized armed groups is how they get this is the recognition that they get in their very specific areas of operation. But the other thing is, I was thinking when you say that the positive, you didn't use the word contribution, but something along those lines is when they prevent access to certain areas, that protects the environment of that area. Indirectly. So basically this is saying organized armed groups don't do damage all over. But I'm not sure whether this is something that it's because it's not just indirect, it's unintentional. It's not. Yes. And I'm wondering whether I mean a lot of actors, state and non-state actors, don't do harm to certain interests. That's not exactly a positive contribution to those interests. It's just fortunately there's not just harm all over all the time. And if the prevention of access has nothing to do with the environmental protection, then why count that? I mean, if the argument is that organized armed groups are not always bad actors, then I think that's an important argument to make. But we only ask questions about organized armed groups in terms of armed conflict, of hostilities. So why suddenly count their contribution or otherwise in other contexts?
Can I add to Ido? Can I add to Ido? Can I add to
Yeah, you got double agreement.
To add to Yael, it's like giving an argument for anti-personal landmines by saying that most animals weigh less than most people, and therefore when you spread landmines all around, you protect the environment. That would be the analogy of what you're making.
I think you just need it. It's not on. Is that an argument?
No, or are you just?
No.
It's not an argument that exists, but I don't know. It's not an argument that exists, but I would say it's analogous to the argument that they are giving a positive contribution because they are not preventing access to that area.
I believe putting landmines is a serious thing rather than restricting national armies from a specific area or the private enterprise or the extraction companies. And that's why we said it's indirect. They don't intend, there is no mens rea, but it's somehow indirectly actus rea. And it's not really what they intend to do, but these are something which is indirectly done by them. So that's why we said it's indirect. Maybe they don't intend this thing, but it's somehow I don't say that and justify the means employed, but...
Can I just add a quick anecdote? I'm teaching a seminar on non-state actors. We had a lesson about organized armed groups. And I'm trying to make the point that not all organized armed groups are necessarily bad actors. So I asked ChatGPT, give me examples of organized armed groups that don't engage in terrorism. So I get an answer about all those that sign up to Geneva Call. And so I say, I'm not asking about commitments. I'm asking about actual practice. And then the answer is, I'm not a great operator of ChatGPT. Okay. So the answer is, when we limit the question not to commitments, but to actual practice, then the list diminishes significantly. And then I get the answer, the Swiss Guard, Kurdish Red Crescent, which I seriously hope does not engage in terrorism. And sorry, the Swiss Guard.
If it's the Red Crescent, that shouldn't be a non-state armed group to begin with.
And Swiss Guard?
Yeah, I know.
And I forget
ChatGPT.
I forget what the third one is. But the point is, it's actually, I mean, contrary to what I've just said, it's actually not that easy to find organized armed groups that are not bad actors. But theoretically, they exist. Yeah.
So ChatGPT rather answer with the Polisario front or?
Polisario engages also in they're not a terrorist organization, but they also attack. Yeah. No, I'm all for Polisario. I'm with you. That was just the anecdote.
But I'm assuming it's also, how does ChatGPT define terrorism?
I don't know. I didn't ask that. I mean,
I'm interested because ChatGPT makes
doesn't know any more than we all know together. Yeah.
I received the long list.
Well, everything is here.
No, those were perceived favorably.
Okay.
How many of them are real? Because ChatGPT.
Yeah, maybe again to turn the mainstream now of the discussion.
I don't want to steer the conversation to a different direction.
Because we have many also questions, also for everybody to have the opportunity to express himself or herself. Just a small note about what else said so far. I think there is a point here, Mohammed, was clarified in our presentation about the intention and the result. I think sometimes you don't have the intention to do something, but accidentally a good thing happens. This good thing maybe shouldn't be so much stressed in favor of the non-state actors. That was the point of Yale, and I think it's something to think about. We continue though here with Svetlana, that has also a question for Barnaba or for...
Can't I do both?
Okay, of course. Even better.
So going back, Mohammed and Mariam, on this question of possible negatives to the environment, I was wondering, beyond this question of substantive obligations that there might be for organized armed groups, I suspect is what you were going for, what are the types of measures that can bear responsibility on these groups? And here I'm thinking about something about compliance, implementation. Do you see some domestic measures that have worked, or international cooperation such as cooperation in criminal matters? So what are the actual modalities of bringing the law to bear on them, whether it's domestic law or it's some metric of international law? So do you see something positive there? And for Barnaba, I was wondering about the distinction between a limitation and a derogation. So how far can one go with the limitation, and in what circumstances should we actually go to the possibility of derogations? Because of course that matters conceptually in terms of the tests that you have to consider. And there's some variance in the practice of states as to how easily they're willing to get derogations, or whether they still try to slide on the scale of limitations analysis.
So should I?
Yeah, please.
Since we are talking about the international legal order, so our work was mainly focused on creating international liability for them, and this maybe should start with the how to balance their legitimacy and their obligation under the international legal order. And as I said in my last part, that there should be the reconstruction of the international legal order, which should be mainly based on the accommodation of both the state and non-state actors. And the IHL should be equally based on the environmental protection at the same footing as the humanitarian, because so far the international humanitarian law is mainly focusing on the human aspect of the conflicts. So these are my.
According to me, a limitation is a sort of derogation is a sort of limitation, but the international law, several instruments foresees how to make that limitation. You're supposed to respect. It's supposed to be for a period of time, emergency, war, etc. And you're supposed to respect some procedure. That means they say how to do it. But once it's over, you're supposed to respect the provision. That means if you don't respect it, you are responsible for human rights violation.
Thank you very much for the comments. We have from Sophia and Yali. Maybe Yali first, Sophia, and then we can go to your question. Yeah, Sophia, please.
Thank you. I have a question from Mohammed and Mariam. I'm not sure whether it's relevant, but I was listening to your presentation and I was thinking about the Houthis. The Houthi attacks against vessels, we had Rubimar, we had MV Sunion, and the attacks basically have posed or are about to pose environmental damage. And given that the situation with the Hutus is quite complicated, I mean, are they an armed group? Are they terrorists? Are there an entity that exercise governmental powers? How are we meant to treat them? I mean, have you looked into that issue at all? And when Ziv mentioned landmines, I mean, they use landmines in the Red Sea. So the fact that these may prevent shipping, will that be a positive impact on the environment if they don't explode?
If they don't explode.
Because, you know, it means that shipping has to be reduced, especially with submarines. So, I mean, is this something that, as part of your research, would classify as something, you know, positive?
Yeah, within our work, we didn't really focus on this aspect, but I believe landmines, be it on sea or land, it is a serious thing, and you cannot justify it no matter how much utilitarian purpose it has for the environmental protection or any other natural resources. So we didn't, but I believe...
Have you looked at all of the status of the Houthis?
Pardon?
I mean, the status of the Houthis. I mean, how would you classify them in your research?
I don't find myself competent to comment on their status, because for me, I haven't done research on Houthis or these things. So commenting on their status, be it armed group or terrorist group or a state actor, I think I don't find myself competent.
Okay, thank you.
So actually the Lava Sea.
Yeah, the junction between the Lava Sea and those of war. So Yali, please, question.
So first, a comment and maybe a question. I had the privilege to hear in Madrid in July a presentation by Laura Baron Mendoza. She's a PhD student from McGill, and she writes about non-state actors and environmental protections, specifically focusing on the FARC in Colombia. And I think that maybe you want to engage with it. I'm not sure to what extent research is already published, but the things are really close and really interesting. In this sense, right, I think that there's a question that keeps coming about what's unique about non-state actors versus state. And I think that at least part of her argument was that indigenous communities or some organizations have specific ties to the environment that allows them to focus more on the protection. And I'm not sure, like, I'm not convinced that it necessarily a non-state actor kind of attachment, right? So we can imagine, at least potentially, that we have the state or a state where the people in the state culturally are really close to the environment, and we have rebels that actually like really hate trees, right? So I'm not, theoretically we can think about it. I'm not sure that necessarily like that usually indigenous or traditional communities treat animals or the environment better. It depends on the specific location and the specific culture. So I wonder to what extent do you think that there are unique aspects of non-state actors that allow to learn something new about protection of the environment compared to states, or is it just a question of legitimacy compliance? And so, and just maybe a brief thing about what Ziv told us. Like, I'm not afraid of an argument like the anti-personal minds argument, right? This is a workshop about contradicting obligations. So we can say for sure that anti-personal minds all argue to the protection of the environment in the narrow sense. It's just that the risk of it clearly outweighs any benefit that we receive from the widespread of anti-personal minds. So I think that it's not a problem to take into account positive aspects of horrible things. And this is a clear example of the positive effect of the horrible things. And more generally, right, human presence is not great for the environment.
It's also not good for other humans.
Yeah. In terms of landmine, I believe we should see the utilitarian calculus, how much damage it is causing overall and how much it is protecting the environment. So I believe that putting landmine for the environmental protection can be nowhere logical or saner.
So there are some red lines that you outlined now. We didn't hear about them so much in the lecture, in the presentation, so it's good now maybe that we can...
exactly.
There are some red lines in the whole structure that you pose.
Yeah, exactly. And I believe it will help us a lot. So.
And we have also two questions from that side of the table. First of all, yes, please.
Hi, so great presentations, both of them. My question was to Mariam and Mohammed. So do you think, is it at all possible that the entire reason why and you gave a specific example about them preventing oil drilling, that is because of the lack of access to technology and nothing else? Because if they did have the access to technology, who knows, they would have done the same thing as, let's say, non-state actors, what they call blood diamonds. Right? So that's one. And second, about the specific suggestion that you gave about recognizing their positive contribution and punishing their negative actions. But do you think the fruit of the poisonous tree argument would apply here? Like if a group is inherently problematic, their actions constitute war crimes and their entire activity is based on, let's say, crimes, do you think recognizing any positive aspect leads to any reasonable outcome, or what would be the consequence rather?
Yeah, so if you're recognizing their positive, you're also holding them accountable for their negatives. And you see recently the state actors are employing non-state actors in order to do certain acts which, being a state and subject of the international legal order, prevent them from doing it. So if you apply the same thing, they will also be prevented from doing these acts. And the point that we say that the preventing extraction companies or private enterprises, we said it's indirect contribution. They don't intend it, but it's somehow indirect contribution to the environmental protection.
Yeah, but then again, the question arises, why should they be credited for this indirect contribution since they didn't intend? Why should they be portrayed with good colors, with positive colors? That was discussed before, so I think it's an open question though. So, Igor, please.
Thank you. Thank you for representations from both of you. I have a question for each one of you. One of us, I'm going to start with you. Do you think the essence or the focus should be on the procedural aspects of derogation or actually on the essence? And I'm going to give you a short example because we've seen during COVID, for example, a lot of states issued emergency or some conditions, situations, and some of them, not all of them, follow the derogation procedure, and some of them haven't. And I think you can see that sometimes those who actually follow the procedures actually use that procedural in order to take advantage and harm more rights than were necessarily relevant at the time of COVID. And some of the states who didn't go through the procedural aspect actually limited the harm to human rights within the framework of COVID in a much better way than others. So the question is, do we care more about the procedural aspects of derogation or the essence of what states do and how they maintain, and even if they didn't follow the procedure of how you should do it, but they cared about the protection of human rights, that should be more encouraged than just focusing on the procedural aspect. And to Mohammed and Maria, I think one of the questions that repeated here was the question of the intention of taking the good with the bad and all that aspect. I think an essential preliminary question is whether or not we are looking whether the acts of the organized armed group or non-state actors are within IHL or we only care about the big direct or indirect effect on the environment. So if they follow IHL and then there's indirect benefit for the environment, it's one thing. But if we don't care if the act was legal or not under IHL, and then we see whether or not it was direct or indirect benefit for the environment, these are two separate passes that have significant different implication of how we look at the action of the organized armed groups. Because if we stay within IHL and you say, okay, they did not violate IHL, and there is the benefits for the environment, then yeah, there is actual legitimacy to say, well, you acted good, let's incentivize that. But if they violate IHL, and then you have the benefit for the environment, then you say, well, as Yali said, I wrote to Bettina earlier, if you kill a lot of people, you improve the situation of the environment. But that would be, against the basic essence of IHL, which is try to reduce the harm to people on the battlefield. So that's the question. Are we talking about within IHL, or generally regardless of their actions in accordance to IHL?
Yes, thank you, Professor. So I do understand your point. And I think that I agree with you also, because if a state does not respect the procedure and the state take the measures that can help people to protect the population, I do see it's not a problem. But the problem is the fact that it's not safe for the state, because if the state that without respecting the procedure, don't forget that the person who is the person who is faced to the situation where there is a restriction of his right, the person of the group of persons, they're not happy. When they see that, they can seize the courts. If you consider the example of the Inter-American Court, if they seize the court, they can be the court can decide in favor of that. Of those persons, because according to the court, in the case of a Zambrano Veles, the Inter-American Court, it says that the non-compliance of that procedure is a breach of the obligation of the Article 27. That's been. For me, what I understand is not safe for the state. If I were in the place of the state, I would respect the procedure. And they criticize some states also that just take measure without respecting the procedure. They say that they make discrimination. That's why the Inter-American Court says that the derogation, the state must avoid doing discrimination when they say that they are using this derogation. I think it's not just to, in your words, in a sentence, it's not safe for the state that does not respect the procedure.
Yes. As I said, like ends can never justify the means employed. And in some cases, as you say, but I have the other proposition or the possibility as well. In some cases, they might be complying very well with IHL rules, but they might be damaging the environment, even though we have the proportionality principle within the IHL, but IHL, as I said, is mainly anthropocentric, like it is mainly focusing on the human protection. And that's why I say within my presentation, like we'll have to increasingly, we have to place a human need in the wider context of the ecological ethics. So I haven't done a lot of research on these questions that specifically are coming, but these are really positive suggestions for our work to further refine. Thank you.
And we thank the participants. If there are no further questions, then we wrap up this panel. And to thank you everybody for the participation, again, the presentations. Please share with me a round of applause for our participants.